In this video, we're going to be talking about express and implied easements, having finished our discussion about the content requirements for an easement in the previous videos. So let's begin by talking about express easements. So the most straightforward way in which X can acquire an easement over land owned by Y is by Y expressly conferring the easement on X. So the most common way an easement arises is where it is expressly conferred. And there are two ways to expressly confer an easement. Express conferral can occur in an ad hoc transaction. For example, Claire, the owner of the freehold estate in Blackacre, grants Richard, the owner of the freehold estate in Blueacre, a right of way over Blackacre. So an easement will arise when neighbours agree it will arise to burden one plot of land and benefit another. Express conferral can also occur on the transfer of land. For example, Claire sells part of Blueacre to you and either grants, so a grant of an easement benefiting the land transferring to you, an easement benefiting the land transferred to you and burdening the land retained by her, or there can be a reservation of easement where she reserves an easement benefiting the land retained by her and burdening the land transferred to you. And the express conferral of an easement will often be in return for some sort of monetary consideration, and the price of the land may be adjusted to take into account the easement. So if you have the benefit of the easement, then the price of that land will go up, and if Claire reserves an easement for herself, then the price of the land will go down, for example. So, an easement can affect the value of the land. So legal or equitable, and as I said before in all my other videos, basically the legal and equitable video is the most important one essentially out of the whole land law series. It is concerned with every single topic in land law. If you don't understand legal and equitable principles and how that works in land law, then you're going to struggle in the exam. But with regards to easements, an easement is a right in rem which is capable of being legal. That's the Law of Property Act 1925 section 1. An express easement will actually achieve legal status if created with the requisite formality, that is a deed and registration. Where the relevant formality requirements are not satisfied, the easement may take effect in equity, and it will do so if there is a valid, actual or discovered via Parker and Tazewell contract granting the easement. So if the easement is created by the transfer of land, then it is likely the formality requirements will be satisfied. However, if the easement is created through an ad hoc transaction, so remember these are two types of ways to create an express easement. So if the easement is created through an ad hoc transaction, then it is less likely the formality requirements will be satisfied. So there's not really much more to say about express easements. The bigger concern and the bigger talking point is all around easements implied into a conveyance of land. So easements will be implied on three different doctrines. We've got the doctrine of necessity, which is really what I'm going to talk for the rest of this video about. And then in the next video, we're going to talk about the doctrine of Wealden and Burrows and the doctrine contained in the Law of Property Act 1925, section 62. And we also need to remember that conveyance will include not only a transfer of the freehold, but also a grant of the leasehold. So the following does apply to both freehold and leasehold. So necessity. The first thing is true necessity. The law impliedly grants or reserves an easement on a conveyance of land where the land transferred or retained is landlocked, i.e. there is no access to the land. The easement implied is a right of way over the retained or transferred land. And the easement is excluded by contrary intention as well. So that can be seen in Nickerson and Barraclough. So if it is clear from the transfer that they did not intend for there to be access to the land, then the law won't imply this easement. The easement is not implied if there is a footpath or even access by water to the transferred land. That's from MRA Engineering and Trimster. And, you could ask questions like, well, how about, access by air? Would that not imply an easement as well? Well, I don't know, who knows? But things to think about. But they said in this particular case is that access by water or footpath to the transferred land would not imply an easement. So let's look at an example, Blackacre example. Now, let's say that Claire owns the freehold of this land and sells part of the land to Gemma, which is in this square here. So the land is completely encircled here. Gemma's land is completely encircled by Claire's retained land. The transfer document gave no express right of way to the landlocked land. But because it is landlocked, the court will imply an easement due to the true necessity of accessing the road to the left-hand side. This easement will grant a bare minimum right to ensure her land is not landlocked and has a right of way to the road. Now, let's say we were to reverse the parties and put Claire in the middle of the landlocked land and put Gemma on the outside. So, we got Claire in the middle here, and let's say we've got Gemma on the outside. So we reverse the parties. Now, Claire owns Blackacre and transfers land to Gemma, but Claire retains the landlocked land and does not expressly reserve a right of way in easement. In that case, the doctrine of true necessity will work the same way. So the law does not just grant easements to transferees, but will also reserve an easement benefiting the land that has been retained and burdening the transferred land. So it works in the same way, regardless of whether, Claire had, landlocked herself or landlocked the person that she sells the land to. So it works both ways. The second type of necessity is common intention necessity. The law will impliedly grant or reserve an easement into a conveyance of land where the parties to the conveyance held a common intention, so it would be for both parties, that the transferred or retained land would be used for a particular purpose, or that purpose is possible only if an easement is granted over the retained or transferred land. Again, the easement is excluded by contrary intention in the conveyance. And in Pullback Colliery and Woodman 1915, so in Woodman case, I'm not even too sure how to pronounce the beginning of this case, but I just would like to call it Woodman because it's easier. In this case, Lord Parker said that the law will readily imply the grant or reservation of such easements as may be necessary to give effect to the common intention of the parties to a grant of real property, with reference to the manner or purposes in and for which the land granted, or some land retained by the grantor is to be used. But it is essential for this purpose that the parties should intend that the subject of the grant or the land retained by the grantor should be used in some definite and particular manner. It is not enough that the subject of the grant or the land retained should be intended to be used in a manner which may or may not involve this definite and particular use. So let's look at a case. So we've got Wong and Bowman properties. In this case, the owner of two buildings granted a 21-year lease of the cellars underneath the buildings. The tenant covenanted to keep the premises open as a restaurant, to control and eliminate all odours from the premises, and to comply with health regulations. Regulation 21 of the Food Hygiene Regulations 1955 required every restaurant to be sufficiently ventilated. On inspection by the public health inspector, the restaurant was held to be in violation of this regulation. The inspector declared that the restaurant must install a proper ventilation system attached to the outside of the two buildings. The tenant asked the landlord if he would agree to the ventilation duct being fixed to the wall of his property, and he refused. The Court of Appeal implied into the lease of an easement giving the tenant the right to put up a ventilation duct on the outside of the wall of the two buildings. And Lord Denning, in this case, said, I would apply the principle of Woodman here. Here was the grant of a lease to the leasee for the very purpose of carrying on a restaurant business. It was to be a popular restaurant, and it was to be developed and extended. There was a covenant not to cause any nuisance and to control and eliminate all smells, and to comply with the food hygiene regulations. That was a definite and particular manner in which the business had to be conducted. It could not be carried on in that manner at all unless a ventilation system was installed by a duct of this kind. The lessee must of necessity be able to put a ventilation duct up the wall. So the Court of Appeal said that they could imply an easement to put up the ventilation duct. There was a common intention, a definite and particular manner, and it would be impossible to comply with Regulation 21 without implying the easement. So let's look at a Blackacre example. Clare is the registered proprietor of Blackacre, a large estate in Cambridgeshire. The estate includes stables and a paddock. Clare does not ride, so the equestrian facilities are not being put up to use. A local riding instructor, Gemma, notices this and asks Clare whether she can buy the land comprising the stables and paddock in order to open a small riding school. Clare agrees and the sale is completed shortly thereafter. The conveyance expressly grants Gemma a right of way over a pedestrian footpath leading from the stables to the main road. This path is, however, too narrow for Gemma's horses. There is a bridle way traversing Blackacre, but no right over the bridle way has been granted in the transfer documentation. Advise Gemma. So there is no express grant over the bridle way, but can we imply the easement over the bridle way? And one way is under a common intention necessity. First thing we look for is an intention that the land transferred be used in a definite and particular manner, and we can see that we have that here. So Gemma is intending to use the land transferred to her in order to open a small riding school. Not only that, we have an intention common to the parties. Gemma tells Clare of her plans for the land and Clare agrees, so both parties hold the intention the land be used as a riding school. Our final requirement to imply an easement under common intention necessity is that the easement be essential to use the land in the manner intended. Again, this seems okay. It is practically impossible for Gemma to use the land in the way she intended as a riding school without this easement. So a right of way of the bridle way is absolutely essential to use the land in the manner intended by the parties. Therefore, the law will imply into the sale of land to Gemma an easement, so a right of way over the bridle way. Okay, but how would our advice change if Gemma buys the land with a view to operating it as a riding school, but Clare is unaware of her plans? So we need a common intention that the land be used in a particular way, and in this sort of scenario there would be no common intention, so the prerequisites are not satisfied and no easement will be implied. What about Gemma buys the land with a view to either operating it as a riding school or to convert it into an artist's studio and outside installation space? So this does not appear to be intended to be used for a definite and particular manner, so again no easement will be implied. How about, in addition to a right over the bridle way, Gemma claims a right to graze her horses on one of Blackacre's fields. And in this scenario, it's not essential to use the land in the manner intended by the parties, therefore Gemma will not have an implied easement to let the horses graze. And finally, what if Clare retains the stables and paddock, selling the remainder of the Blackacre estate to Gemma? The parties intend that Clare will henceforth operate the retained land as a riding school. Clare will have an implied easement under common intention necessity used the bridle way here. So in other words, the easement can be impliedly granted and impliedly reserved. So that is the beginning of our discussion and the end of the first video with regards to express and implied easements. In the next video, we're going to really dive into implied easements a little bit further by looking at Wealden and Burrows, which has a lot of discussion around that particular case, and looking at the Law of Property Act 1925, section 62, which is general words implied in a conveyance. If you have any questions about this video, please leave a comment below and I'll get straight back to you. Make sure you subscribe to my channel because there'll be new videos almost every day. Thank you very much for watching.